Hello, ma'am.
Start sharing your screen, ma'am.
Ma'am,
Now it's clear.
ma'am, mute la irkeenga, ma'am.
Ma'am, now we can have it on the Zoom, ma'am. I'll just cut the call, ma'am. Ma'am, I'll cut the call, ma'am.
Yeah, please.
Yes, ma'am. Yes, ma'am.
Hello, ma'am.
Yeah.
Speaker off
You are audible?
Yes, ma'am.
Yeah, fine.
We are able to hear you.
Yeah.
Hello, ma'am. This is Dr. Varadi.
Hello, ma'am. Yeah. Nice meeting you, ma'am.
Yeah, great meeting you, ma'am.
Yeah.
Ma'am,
Is my voice is clear, ma'am?
yeah, it's clear.
Yeah.
Ma'am, screen share பண்ணி check பண்ணிக்கலாமா, ma'am?
Screen share பண்ணிட்டுமா?
ஆமா, check பண்ணிக்கலாம், ma'am, before we start the session.
Okay. என்ன பண்றது, ma'am?
green color ma'am screen sharing னு சொல்லிட்டு green colorல இருக்கா ma'am கீழ மவுஸ் அப்படி கீழ
ஆமா share ன்னு இருக்கு
ஓகே
ஸ்டார்ட் பண்ணிட்டீங்க ma'am நீங்க
ஓகே இப்போ PPT ஓபன் பண்ணுங்க ma'am உங்களோட டெஸ்க்டாப்
ஓகே
Okay ma'am perfect ma'am
okay
full screen வச்சுங்க
ma'am நீங்க PPT full screen வச்சுக்கோங்க ma'am
okay fine
sir admit பண்ணிரலாமா இல்ல கொஞ்சம் வெயிட் பண்ணலாம்
டைம் 1:30 ஆகும்
okay
ma'am இன்னும் ஒரு 2 to 3 minutes will wait ma'am participants வர்றதுக்கு will wait
okay ma'am okay fine
okay ma'am yes ma'am
இல்ல சார் அவங்க ஷேர் பண்ணல.
ஷேர் பண்ண சொல்லுமா. Hello, ma'am. Am I audible, ma'am? Hello, ma'am. Our video is muted. Ma'am, your audio is muted, ma'am.
கொடுத்துட்டேன்.
Ma'am, you can unmute yourself, ma'am.
Yeah, I have unmuted.
Yes, ma'am.
Yeah.
Ma'am, you can start sharing your screen, ma'am, so that I'll give a small introduction, then you can go ahead with the session, ma'am.
Okay, 1 second.
இல்லடா ஆன்ல இல்ல. போட்டோ தான் வருது.
Yeah, ma'am.
Yes, ma'am. இப்போ என்னது நம்ம பேசுறது 2-3 இடத்துல இருந்து கேட்டுட்டு இருக்குது.
இல்ல யூடியூப் போறேன்.
மேடம் பிபிடி ஓபன் பண்ண சொல்லுங்க. Ma'am, you can open your PPT, ma'am.
ஓபன்ல தான் இருக்கு.
Yeah.
பேங்க்ல கூட 2 க்ளோஸ் ஆயிடுச்சு.
சரி எனக்கு ஒரு காசோட சார் சுத்தமா காசு இல்ல சார். அப்ப பஸ்ல போறது காசு இல்லாம அழுவாங்க.
நீ பண்ணுங்க.
I welcome you all to the third session. A very good afternoon to one and all present here. I take this opportunity to introduce our expert for this session, Ms. P. Iladangai. Ma'am has obtained her bachelor degree in Electronics and Communication Engineering from Government College of Engineering, Salem, Madras University. Her present designation is IPR Consultant, Patent Agent. The services offered are IPR protections such as search, drafting, filing registration, renewals, opposition, legitimations of patent, and industrial design. Madam has also been a senior associate with patents and industrial design at Atlantic Global, Chennai from the year 2008 to November 2016. Madam is also a faculty for the certificate course on patent drafting conducted by Tamil Nadu Technology Development and Promotion Center of Confederation of India. Madam has also conducted many workshops and delivered guest lectures relating to patent and design at various premier institutes all over the country. Now I hand over the session to you, ma'am. Thank you. I will once again welcome you, ma'am.
Yeah, thank you, ma'am. Good noon to all present here. Thank you, ma'am. Thank you for giving this opportunity for me to be a part of this session. So I'll be just concentrating on patent specification drafting. So hope the participants would have had a awareness on IPR in the morning sessions. So my session will be only to patent specification drafting. So we'll move on to this. So before going into the patent specification drafting, I'll just give an introduction of what is about the patent drafting and all. And so once you have an idea in your mind, a subject matter, so if you feel that it is really entitled to have a patent, then you have to write the invention in such a way that it should be described completely. So you have to describe the invention completely in your patent specification. So a patent specification is nothing but it is a techno-legal document, which means that technically and legally it has to be drafted in such a way that you claim for the right subject matter in the patent specification. So when you've come up with a subject matter which is considered as to be a patent, then it should have the criteria like it should have novelty and it should have inventive step and industrial applicability. So hope you are aware of this patent criteria. So if it is to be new, then it is considered as that invention, whether it is to a product or to a process, it should not be existed at the time of filing your application, and it should have an inventive step. So describing something new that has not previously existed is more of a challenge than most people realize. Many times those new to the industry fail to adequately describe the invention because the invention is obvious to them and they think it will be equally obvious to the others also. So the applicant or the inventor who is writing the patent application should be very clear that he should write the specification in such a way that the non-obviousness, that the technical advancement which he has brought in his patent, it should be written in such a way that a person skilled in the art should be able to understand the invention clearly, and he should be able to perform the invention whatever you have described in the specification. So you have to explain the uniqueness of the invention. When an application is difficult to read, for example, to open a patent document, whether it is to your irrespective of any field of technology, when you open a document and read that document, it hurts you if you are not able to understand the specification, like what they have written and what they are trying to claim for. Okay, so because of which you just skip some of the pages and you go and you simply sign it. So that is not like how you read the specification. So whether you yourself draft it, or when you give the invention to some others to draft the specification, you should be able to understand what they have written and how they have written and what you want to claim as a protection and what you want to have a protection for a period of 20 years. So a poorly drafted patent may leave open doors for the litigants on either side to interrupt the language in an unintended way. So maximum, if you see, one of the biggest mistakes the inventors make is spending too much effort in explaining what the invention does. They will say, my invention does this one, it performs this work, it does that, it etc etc. They will be explaining what the invention does, and they just spend very little time in describing what the invention is and how it works and delivers the described functionality. So you have to structurally, functionally explain how your invention works, rather spending in time on what the invention does. And also it is very important to take time to describe how your invention is different from the existing prior arts with regard to the material or with regard to the special one or more components which is very new to your invention. And another reason for the inventors to fail to accurately describe the specification is they hide some of the test results. They try to hide some of the essential features which they do not want to disclose it publicly. But that is not the case. If you want to have a patent protection for your subject matter, you have to completely disclose what the invention is about and how it is working and what is the technical advancement you achieve based on the invention you have come up. If you want to hide it, then it should be kept it as a trade secret and you should not file for a patent application. If you want to have a patent application filed and have a patent granted, you have to completely disclose about your invention in a techno-legal way in the specification. So that's what I want to give a gist of the how important to draft the specification. So now let's see the other things that has to be followed while drafting a specification. So as I said, to file a patent application, an applicant must fully and completely describe the various features constituting the invention, and also he has to disclose the best method of performing the invention in the specification. The disclosure should be in such a way that it should be able for a person skilled in the art to perform the invention based on the inputs you are providing in the specification. If you give any false information, what happens is if anybody sees to the specification and if he is not able to perform the invention based on the writing which you give in the specification, then it will be one of the important objection to be raised in the examination report or in the opposition, that they will ask the controller to reject the application, stating that it is insufficiency of disclosure and based on the specification, I'm not able to perform the invention to the fullest extent, and whatever the information given in the specification is false information, and hence a patent should not be granted to this applicant. So this is how the opposition comes or the rejection comes for a specification when you are not writing it in a full complete manner. So now let's see about this patent specification drafting. Here you have two types of specification drafting. One is the provisional specification and the other one is the complete specification. What is this provisional and complete? I'll just give a quick brief of this provisional specification. So when you are coming up with an idea and you feel that your idea is eligible for a patent application, but you have not completely completed your invention and it is not ready for to be come to the market, which in that scenario, if you feel that it has the patentability criteria, you can first file this provisional application with the patent office and then get a patent application number and date, which is a provisional application is nothing but a temporary application, a simple, a brief disclosure of your invention is sufficient to file a provisional specification. And this provisional specification is a permanent and independent document and no amendment is allowed for this provisional specification. So what are the when you want to draft a provisional specification, when your idea is an initial stage and if you want to draft a provisional specification, what are the subtopics to be covered in a specification? So when you write a specification, you have to start with the title of the invention, the field of invention, a background of the invention, and the intended objectives you have achieved based on this invention. And if there are any drawings, that drawings can also be a part of the provisional specification. Please be noted that the drawings are not mandatory for filing a provisional specification, and claims. And this particularly, these claims are optional. According to Indian Patent Act, claims are not mandatory at the time of filing a provisional specification. But if you are filing a provisional specification in a foreign country, say for example United States, then there it is mandatory to file with one broad claim along with the provisional specification. And in case so next we'll see to the complete specification. So when your idea is at the fullest extent, you have completed the research and you have come up with a very good result, and you have you are about to commercialize the product, or if you are going to bring that product to the market, so everything is ready, then you can directly file a complete specification with the patent office. If you are going to file a complete specification with the patent office, as per section 9 and 10 of the Patent Act, the complete specification should fully and particularly describe the invention, its operation, its use, and the method by which it is to be performed. It should disclose the best method of performing the invention which is known to the applicant and for which he is entitled to claim the protection. And the structure of the complete specification, if you see, it will be similar to a provisional specification with one or two subtopics added. So for example, it will start with the title, then the field of invention, then the background art, then the objects of invention, summary of invention, brief description of drawings, detailed description of the invention with reference to the drawings, and the last but not the least, the claims. These are the mandatory subtopics that has to be made when you draft a specification and submit it with the patent office. So now let us see how to draft each and every subtopics. So I told you that you can file a provisional or complete. What is that provisional or complete? I told if the idea is in initial stage, you can file a provisional. If your product is completely ready, you can directly file a complete specification. So what is the advantage of filing a provisional? Let's see that one. So a provisional specification secures a priority date for your application over any other application which is likely to be filed in respect of the same invention being developed concurrently. So if you have a subject matter in your mind, similarly, many people all around the world will have that same thinking, and people will be filing for similar subject matter with the patent office. So if you want to have a patent protection for your subject matter, you should secure a priority date before anybody files similar to that subject matter. So this provisional specification secures a priority date when compared to the other applications which is filed similar to your invention. So as I said, that provisional should fairly disclose the subject matter to ensure the priority right. And then after filing a provisional specification, then when you have to file a complete, so we know that provisional is a temporary application. So you just cover the broad features of the invention, right? So within the 12 months time from the date of filing the provisional, you should file a complete specification to claim the priority date from the provisional. So whatever subject matter you have disclosed in the provisional, you should describe it, explain it in a broad way, in a detailed way in the complete specification. No new subject matter can be included when you draft the complete followed by a provisional. Whatever subject matter, if you say, for example, if you talk about a pencil and a process of manufacturing the pencil, so that detailed explanation of that product should be there in the complete. You cannot deviate and you cannot include a new subject matter in the complete specification. If it is a continuous, then only you can claim the priority of the provisional specification which you have filed, and then you can have the complete specification. So your complete specification should be filed within 12 months from the date of filing the provisional specification. And when you file a provisional or a first filing, then you can use the term patent pending on the product. You can see many products which is available. You can see the word patent pending, which means that it is like, boss, I have filed a patent application and it is pending before the patent office. So you are just intimating the others that a patent application has been filed for this product or process. Okay, and so within 12 months time, you have to file the complete specification. So you have the 12 months time. So for example, if you feel that if your subject matter is not that much enough to have the technical advancement after conducting a search, then if you feel that it's not worthwhile to file a complete specification, you can just leave it and it will get abandoned. If you don't file within 12 months time, your application gets abandoned. So and if you are very sure that it will have a very good commercialization once a patent is granted, then you can continue and file the complete specification within the 12 months time. Then complete specification can be filed in two ways. So it can be a subsequent filing, which means that filing a provisional within 12 months time, you can file a complete claiming the priority from the provisional specification. Or you can directly file. So if everything is ready, you can directly file a complete specification with the patent office. So what all is required to draft a specification? I gave a brief description, introduction, like what is the need for, like how you have to draft the patent specification. What is the importance of drafting a patent specification? So what all the gist you would require to start drafting the patent application. Okay, so when you come up with your product, surely you will have a title. So apart from this invention, if your hobby is writing a story, what you do, you will have a title for the story. Unless the title is clearly indicating what the story is, then there will be surely a mismatch. Then we will normally say, title like that we normally tell, right? So your title should clearly indicate the subject matter of the invention. So you have to start with the title. So why did you come up with this invention? What is the necessity for you to come up with this invention? So the answer will be like, you would have seen a similar prior art, a product in the prior art, and there would be some disadvantages or drawbacks in that prior art. Based on the drawbacks, you would have come up with your solution. So that solution will be your invention. So what is the purpose of the invention? So what differences you have brought when compared to that prior art? That will be the inventive components, features and components of your invention when compared to the prior art. What is the use of the invention? And what are the technical comparisons you have brought when compared to the prior art? And of course, the advantages. So all this has to be kept ready before you start to write your patent specification. These are the important information which is required before you start drafting a patent application. So now I told that there are various subtopics that has to be mandatorily included in a patent specification. So the first subtopic is the title of invention. As I told, for a story, you have a title. Similarly, when you come up with a product, you will be having a title for that product or to that process. So that whatever title you keep, that title should be clearly indicating the inventive feature of the invention. It should be precise, meaningful, and the most important point is, as per the Indian Patent Act and rule, the title should consist of only 15 words, 15. It should not go beyond that 15 words. Okay, whatever is your invention relating to that, you have to keep the title. So that on seeing to the title, one should be able to understand what your invention is about. So for example, if you see to the first title, folding chair. So from the title, it is very clear a person has come up with the chair which is foldable type. So based on the title itself, one should be able to clearly understand what they have come up with the invention. Similarly, with the second title, reusable multi-layered diaper. So if you read to the title, it is very clear that it is to a diaper and it is a reusable type and it is a multi-layered diaper. So all that it comes in the title itself. So it is very clear that it is related to the diaper. Then when you see to the next title, weighing apparatus for visually challenged. So here, if you see, he is claiming for a weighing apparatus and he is specifically mentioning for whom it can be used. So which means that your title can also tell the purpose of the invention. So otherwise you can, if you have come up with a weighing apparatus which is universal, then you can simply claim the title as weighing apparatus. Or if you have come up with a weighing apparatus which is specific for specific persons, then you can tell the purpose also in the title. Here, the weighing apparatus for visually challenged means it is only for the disabled persons or visually challenged persons, this weighing apparatus. So I want to have a protection for a weighing apparatus which is only for visually challenged and not for the normal persons. So you can tell purposely the purpose of the invention also in the title, and please keep my noted that your title should not be more than 15 words. And the other title example is herbal hair care composition. So you have come up with the hair care composition which is made of herbals. So the title is clearly indicating what is your invention is. This is how you have to frame the title. And my next slide, I have just given which contents are not allowed in the title. You can see many people would have written a title along with the inventor name also. That is not, as per the act and rule, it is not allowed. So how one can understand the invention with the inventor's name? Say for example, Geeta pen. What that Geeta means? What does it describes about the invention? No, it's a simple name. So you cannot include a name which is not describing your invention. Your title should describe your invention. A pen means, yeah, you're talking about some pen. So that is your title of the invention. That is acceptable. But a title with an inventor's name is not allowed. And the word patent. Some people write patent with the title. A patent, for example, patent pen stand, patent mobile device, that is not allowed. Words in other languages, it's not allowed. Abbreviations and etc., that is not allowed to be in the title of the invention. When you want to use some standard words, the standard abbreviation, even then you have to give the expansion. You completely avoid using that abbreviations in the title. And some people, if you see the title, they would have kept fancy expressions: wash well soap, intelligent cooking stove, What does it mean? Wash well soap, as if other soaps doesn't wash well. So wash well is a fancy expression that not, see, the words which does not talk about your invention should be completely removed from the title. And intelligent cooking stove. How you can define intelligent? Your invention is to cooking stove. Yeah, I can understand you are claiming for a cooking stove. What does mean intelligent cooking stove? Novel cooking stove. So these are the words you can see. Even some in title with the words, with the fancy words have also been granted in earlier times. But the actual procedure as per the manuals procedures which is available with the patent office, the words which is not describing your invention should be completely removed from the specification. Okay. And one more point I would like to highlight here is you can claim for both product and process in a single patent application. Say, for example, you have come up with the soap. Okay. It is a herbal soap made of 5 herbals, say, for example. So you can claim for the novel and inventive herbal soap, and if you have come up with a very unique process of preparing that soap, then you can include that procedure of manufacturing that soap also in a single patent application. We call it as product patent as well as process patent in a single patent application, provided it should have unity of invention. It should relate. The product and the process should be interlinked to each other, and it should relate to each other. It should not be a new subject matter. Okay. So you can claim a soap as a product and a process of manufacturing the soap as a process in the single patent application. In that scenario, your title should indicate the soap as well as the preparation of the soap. So, for example, herbal hair care composition, otherwise a herbal soap, the title should be herbal soap and a process of manufacturing the herbal soap, which means you are saying that, boss, I want to have a patent application and I want to have a claim protection for the soap as well as the process of manufacturing the soap. If both the product and the process have novel and inventiveness, then it will be granted for the soap as well as the process of manufacturing the soap. In that case, your title should clearly indicate the soap as well as the preparation of the soap also in the title. Here I have given a simple, very simple example for you to draft the title of the invention. It won't take much time. I will just read that one. Previous system comprises several major types of felt tip pens and covers, none of which have erasers. The need is a felt tip pen with an eraser placed on or near the end of the cover of a felt tip pen. This eraser need not be large since it would not necessarily be used to erase an entire board, but rather to simply make corrections. What is also needed is a felt tip pen eraser can be removed and fitted on a different pen. Assume this is a paragraph of your invention. So they are saying that they have come up with a felt tip pen, which is like a micro tip pencil, similar to that. Okay. Pen or pencil, and then a eraser is also attached to that felt tip pen. That is what they are trying to say, and they are saying that eraser is not a very big one, like to completely erase a whiteboard. It's simply a small eraser to make some small corrections. So that is what they are trying to claim, and also they are saying that this eraser can be removed and it can be attached to a different pen also. This is what their invention is. So now, based on this, how you will draft the title of the invention. So what you have to do is, now you have to analyze the invention. Simply reading a first sentence, you should not frame the title. You have to read 2-3 times the invention, analyze the invention, and then see how to frame the title, whether the invention is to a product. whether the invention is to a process, or they are claiming to a product, or they are claiming to the process, or whether they are claiming for both the product and the process, whether they are claiming a specific part or the whole invention. And from that, based on that analysis, you have to come to a conclusion and then draft the title. So when you read that earlier write-up, say for the spell tip pen, so it is to a product. Are they claiming for the process? No, they are claiming only for the spell tip pen with an eraser. So it is very clear, right? So based on that, you have to frame the title, field, objects, etc. So now, based on that, these are very suggestive examples. Please don't think that this is the correct title. These are some examples which I have given based on the write-up which is given. Just 2 or 3 sentences of the write-up. We have drafted some titles. These are suggestive titles alone. Felt tip pen cover with eraser, or felt tip pen with detachable eraser, because they have told that this eraser is removable and it can be attached to another pen also. So seeing to that, you have to frame the title. Okay, I hope it is clearly understood. Then after drafting the title, you have the next subtopic to be covered is the field of invention. The field of invention is nothing but it is a general statement to describe to which field your invention belongs to. And you have to briefly relate the subject matter to which the invention relates. And of course, sometimes you can add some advantages also to the field of invention. For title, you should limit your words for only to 15, whereas for the field of invention, it should be in a paragraph, and there is no word limitations for drafting the field of invention. As per the nomenclature, this is how they start writing the field of invention, as I have given in the example. The present invention relates to, particularly the present invention relates to, more particularly the present invention relates to. So this is how they make the field of invention in a paragraph. So based on the earlier example, I have given a suggestive field of invention. So first point is it should tell to which field it belongs to. So the present invention relates generally to the field of writing instruments, particularly to felt tip pen. More particularly, the present invention relates to a felt tip pen with detachable eraser. So this is how you can write the field of invention. So it should start with to which field it belongs to, and then a brief of the subject matter of your invention. And sometimes you can add the advantages also in the field of invention. It will be like a paragraph. Okay. So this is how you write the field of invention. So the next subtopic is the background art. Of course, there is no hard and fast rules to be followed while drafting the background art. A background art is nothing but it should describe the state of art, particularly to the technical area to which your patent relates, and what is the problem remaining to be solved or the disadvantages. Of course, how an invention comes to your mind. You see the existing prior arts available, you take the drawbacks or disadvantages in that prior art, and then you come up with the solution for that drawback, right? So that's how an invention comes. No one comes with a new rocket science or discovery or something. So whatever it is already available, you make some improvement, you make some modifications, and you show the technical advancement, and you file a patent application, right? So that's how it's a problem solving solution. So you take a problem in hand, bring up a solution, and prove the technical advancement of the solution you have come up, and file a patent application. So in your background, you have to clearly list out what are the prior arts you have come up, you have seen, and what are the drawbacks associated with the prior arts. So all this that has to be present in the background art. So the prior art should be effectively before the effective date of the patent application you are filing. And prior art is any evidence that your invention is already known. What is a prior art? It can be anything that is previously available globally in the world. It may be, it doesn't mean that it should exist physically or commercially available. It may be available in some way to the public. It may be a patent application. It may be publications, journal publications, conference papers, or any brochures which is available in the internet, or any products which is available in the market. All will be considered as a prior art for your application. It doesn't mean that it should be of a patent application. It can be anything which is available to the public. That will be considered as a prior art. Whichever the applicant is known as a prior art, he has to read that one, disclose the drawbacks in that background art. So every drafter has his own customized way of writing the background. Similarly, while drafting a background, you don't have any word restrictions. You can write it with one paragraph or two paragraphs, or how much ever you want to explain it. Only thing is, your complete specification or a patent specification with up till 30 page, no fee. If you go beyond that 30 pages, for each page you have to pay extra fee. So that is how the patent office collect the fees from you. So your background should be in such a way that you should talk only about the existing product or process available in the prior art. You should never disclose about what your invention performs. If you innocently or ignorantly write about your invention in the background, then your invention will be also considered as a prior art. So don't disclose anything about your present invention in the background art. All it should be of the already or existing product or process available in the market. So your background should be in such a way that it explains what it lacks, will in a subtle way demonstrates the importance of your invention, which is the goal. You should clearly bring out the technical problem and the technical solution you are achieving for the technical problem. So that's how you have to draft the background art. So the next subtopic. So you draft the title, you draft the field of invention, then the background art. The next is the object of invention. So the name itself implies the object. So what is the purpose of your invention? What is the intended objective of your invention? Why did you come up with this invention? What made you to arrive this technical solution? So all that, the need of this invention should be clearly made it under the subtopic objects of the invention. So when you talk about the purpose or the intended objective, you obviously tell the technical effect which you have achieved. So that has to be made it under the subtopic objects of invention. So each and every object should be written in a separate sentence. It should not be in a paragraph. Each and every object should be in separate sentence, and there are no word restrictions for objects of invention. You may have 2 objects or some 10 objects also for your invention. So that's up to the subject matter which you want to have a protection. So for example, if you take that herbal hair care composition, the first object will be, I'll just show the nomenclature that is being followed for writing the objects of invention. The primary object of the present invention is to provide. If another object of the present invention is to provide, yet another object of the present invention is to provide. This is the nomenclature that is to be mandatorily followed when you draft the patent specification. Okay, as per the Patent Act and rule. So when you think of that earlier title example, that herbal hair care composition. So your first objective will be, the primary object of the present invention is to provide a herbal hair care composition. Okay, then you can tell that it is a completely, another object of the present invention is to provide a organic based herbal hair care composition, wherein it's another object of the present invention to provide a herbal hair care composition which is completely free of chemicals. I'm just giving some objects to be added. Then you can tell that wherein it's another object of the present invention to provide a herbal hair care composition comprising of tulasi. You can list out the herbals which you have used in that herbal hair care composition, and whatever the object you have achieved in that herbal hair care composition, that also can be included in the under the subtopic objects of invention. The next is that the summary of invention. Okay, please be noted that when you write a provisional specification to have a priority date, to claim the priority date when your invention is an initial stage, then the subtopics to be covered are title, field, background, and objects of invention. That is enough when you write a provisional specification and you can submit it with the patent office. When you draft a complete specification, whatever structure I told in my previous slide, that has to be followed. So you should start with the title, field, background part, objects of the invention, then comes the summary of invention. In this summary part, you have to give the give the details of the invention and the method of performing the invention. So various distinguishing novel features of the invention for which you want to have protection should be made it in the summary part, and it can have different aspects of the invention. For example, if you are claiming for a product, in one aspect you can claim for a product. In another aspect, you can clearly explain the process of that product. So different aspects of the inventions can be brought under the summary of invention, and this format has to be followed while drafting a complete specification. In other words, whatever you want to have a protection under the claims, that will be a reproduction of that will be in the summary part. Okay, whatever you want to have a protection, if it is to a product, that complete technical information of that product will be under the summary of invention. And in another aspect, you can claim the process also. So if you see to the nomenclature that is being followed is, according to the basic aspect of the present invention, that is provided a product comprising of A, B, C, D. It's another aspect of the present invention to provide a process of preparing that product. You can list out the steps of preparing that product. That will be considered as another aspect of the invention. So whatever you want to claim, so you want to claim a product, that whatever subject matter you want to claim, that will be under one aspect. Whatever process you want to have a protection, that will be in another aspect. This is how you write different aspects of the invention under the subtopic summary of invention. Now, then when you write a complete specification, and if your invention is to a mechanical or electrical or electronics where without a drawing you cannot explain your invention clearly, then you can include the drawings along with the patent specification. If it is, say, for example, the earlier example, felt tip pen cover where an eraser is attached, that you can clearly give some 2-3 figures how the felt tip pen cover is and how that eraser is attached to that cover. So all that you can, with reference to drawings, you can clearly explain the invention. So in that scenario, you can have the subtopic called brief description of drawings. So here you have to briefly illustrate the various figures which you are going to submit it with the patent office. Say, for example, if you want to submit some 2 or 3 figures, or even if 1 figure, so you have to clearly illustrate. Figure 1 is the cross-sectional view, or figure 1 is the felt tip pen cover according to the present invention. So figure 2 is the exploded view of the felt tip pen cover or cross-sectional view. How many ever views you want to submit to clearly explain your invention, that many figures can be included. That brief description of that figure should be under this subtopic, brief description of drawings. So I have given some illustrations. If you see, figure 1 illustrates a system according to the present invention. Figure 2 illustrates an exploded view of the device. And if you are claiming for the process of manufacturing a product, then you can very well submit a flow chart along with the patent specification. So figure 3 illustrates a flow chart of the manufacturing process of a filter. Or if your invention is to any biotech inventions where you have to submit some graphical representations, bar graphs or any other graphs, that also can be included, and that brief illustration should be given under the subtopic, brief description of drawings. Here I have given some illustrations. This is how you have to submit the drawings as per rule 15 of the Patent Act and rules. So a clear line drawing, preferably in black and white. No photographs are allowed when you want to submit it with the patent office. So you cannot submit the photographs. A clear black and white line drawing, 2D or 3D drawing, which clearly talks about your invention, has to be submitted with the patent office. No brief description should be there in the drawing. It should be referred with the reference numerals. Say, for example, if you see here, part 4 is similar to like a steering wheel. You cannot say that is to a steering wheel. You should not give the description there. It should be only be illustrated with the reference numeral, any part number. That part number may be numerals, alpha numerals or alphabets, whatever. You should be uniform throughout the specification. When you submit different figures, say for example, this is a front view. If you want to give some other view, 4 should be only to the steering wheel. In our next figure, 4 should not be to some other part. So 4 throughout all the figures which you are submitting, wherever that steering wheel is visible, that steering wheel should be denoted as part number 4. It should not be given a different part number. Okay. And so this is how if it is to a whole invention, you can give a complete picture of your invention in this way. And if you want to give an exploded web view where you want to show some internal parts and then explain with reference to this figure, then you can give an external exploded view with clearly indicating the part numbers. And as I said earlier, if it is to a process of preparing a soap or something, then the different steps that has been done to perform the invention, that steps can be made as a flow chart and submit with the patent office. And any bar graphs, any graphical representations can also be submitted. As I said, as per rule 15, there are certain rules and regulations that has to be followed while you submit the drawings with the patent office. Okay. So it should no drawings or sketch which would require a specific illustration of the invention should be made there. At least one copy of the drawing should be clearly prepared on a durable A4 sheet, single-sided sheet with clear margins as they have mentioned. So at least 4 centimeter on the top and left hand and 3 centimeter on the bottom and right hand of the every sheet. You can have 2 figures also in a single sheet, but every sheet should be numbered serially. Okay. And in the left hand top corner, the name of the applicant should be made. And in the right hand top corner, the number of sheets and the consecutive number of each sheet should be made. And in the right hand bottom corner, the signature of the applicant should be made. In each and every sheet of drawing, the signature should be placed. And no descriptive matter will be made it except in flow charts. So here I have given a simple illustration like how it has to be submitted based on rule 15 of the Indian Patent Act and rules. So the name of the applicant should be on the left side with the number of sheets. If you are submitting with 2 or 3 sheets, the total number of sheets and what this particular sheet is to, sheet 1 of 2, figure 1. Then the drawing with the part numbers, a line drawing, and the date should be on the left bottom. and the signature of the applicant. This is how you have to take the printout and submit it with the patent office. All the drawings should be collectively submitted after the it should be arranged such that after the complete specification, the drawing should be there. So now you have given the brief description of drawing. And please be noted that the drawing should not be in between the complete specification. All the drawings should be in separate sheets. So after you write this complete specification, then the drawings to be finally attached at the end of the specification. So you should not include the drawings in the middle. Of course, you can have some tabular columns in the middle of the specification, but the drawing should be at the end of the specification. Okay. So after you give the brief description of drawing, now what is the next subtopic is brief description of the drawing, detailed description of the drawing with reference to the flow charts or drawings which you are submitting. So based on the drawing, now it's in your own way, you can clearly mention with reference to the figures. And when you refer to that figure, you can see the nomenclature as referring to figure 1. The invention comprises of the components A, B, C. And you have to further explain how the components are attached and how it is working. On the whole, what is the outcome of the end product of your invention. So this is how you have to write your invention with reference to the figures. You can refer 2-3 figures also when you want to explain in a paragraph. So how it is to be written? I'll just give a quick outline of how you have to write. Say, for example, that felt tip pen cover itself. Take that example itself. So it is a felt tip pen with cover and eraser. So now you referring to figure 1. The present invention relates to felt tip pen cover, and that a device or a writing instrument. Then you can say this writing instrument comprises of the various components there in your invention. You have to list out the various elements or components in your invention with the part numbers, and then you have next, after listing out the part numbers, components, you have to tell how that components are interlinked to each other, how they are connected with each other. So the tip and the cap, etc. So how one-to-one it is get connected. So the connectivity, you have to explain it in the next paragraph. After telling the connectivity, the functionality of each and every component can be explained in the next paragraph. On the whole, how your invention is working, the best method of performing your invention with some illustrations can be covered under this detailed description of the invention. And you can give some lot of illustrations and comparisons also. And one more point I would like to make it is, in the brief description of the drawing or in the drawing sheets, you can also include the prior art drawings. If you want to give some comparisons and then explain your invention, you can also include 1 or 2 figures of the existing products which are available. In that scenario, your brief description should be in such a way that figure 1 is the conventional pen according to prior art, or it is a pen according to prior art, which means that you want to give the comparison with the prior art and with your invention. So in that way also you can explain your detailed description. So you can also have the prior art drawings also in the description or in the specification, but you have to clearly mention that it is a prior art. One should not get confused which drawing is yours and which drawing is yours in the sense the present invention and which drawing is to the prior art. A clear distinguishing feature should be there when you explain it. Okay. And so in that scenario, in that way, you have to completely describe the detail. A biotech invention where it is to your composition and where you have lot of components, and the end product which is available in syrup form or a tablet form, the end components will be different with different percentages, And if you want to submit some test results, that also can be included. So as the name implies, the complete specification should completely describe the invention, and you cannot hide anything. You cannot keep it a secret. Whatever things is required to explain your invention has to be completely included in the complete specification, because you will never ever get a chance to add that one. Even if you feel that it could be added, it cannot be added after that, after filing of your patent specification. So all the test results and all the analysis and charts or flow diagrams or figures, whatever you wish to add, everything should be added at one time in the complete specification in the first instance. And whatever figures you include, a clear detailed explanation with reference to drawing should be included and submitted with the patent office. Okay. And you the other terms in other languages are not allowed when you write the complete specification. So you can provide the English equivalents. Words which are not clearly defined, words that are vague, that is not clearly defined, should be completely avoided when you make a complete specification. Otherwise, you can write it in a simple language and submit it with the patent office. And you can use some illustrations also to provide the best method of performing your invention. As I said, when your invention is to your biological biotech invention, where you are using some biological material, in that case, if that biological material is not available to the public, then that should be deposited in order to make the application complete. So the deposition shall be made in the International Deposition Authority under the Budapest Treaty on or before the date of filing the application. So if you feel that if you have come up with the invention where a biological material is used, and if that biological material is not available to the public means, then before you file a patent application, it is mandatory that you submit, you deposit that biological material in the with the International Depository Authority. For example, in India, you have it at MTCC in Chandigarh and Microbial Culture Collection at Pune. So for further information, you can just click onto this website and see what are the categories of biological materials that has to be submitted. They have given a very detailed explanation. If you are very new to it, you can have it is very user friendly. You can see they have listed out the various biological materials that has to be submitted with the International Depository Authority, and then you can deposit that one before you file a patent application. And that after submitting that, you will get some acknowledgement number. So that reference to that such biological material should be made it in the specification within 3 months from the date of filing the specification, giving the in name, the address of the institution, and the date and the number of the deposit of the material at that institution. Okay. And for example, if you are coming up with a soap made of herbals, for example, tulsi, turmeric, neem, whatever. So the source and the geographical origin of that biological material which you are using should also be disclosed in the specification. And then no intellectual property rights can be given unless and until you get the permission from the National Biodiversity Authority. If you are using any biological material like traditionally known ingredients, so that biological resources, if you are using that in your invention to come up with your product, then that biological resources obtained from India should you have to get a prior permission or approval from the National Biodiversity Authority. We call it as NBA. So before filing the patent application, you should go to that website NBA, and you have to disclose a brief disclosure of your invention with your personal details. Immediately you will, by that form is form 3, and along with that form with the prescribed fee, you have to enter all the details and get the acknowledgement receipt. And then in form 1 of the patent application, there declaration will be there, a column will be there. If you are using a biological resources, that has to be put a tick, and then along with that you have to submit the acknowledgement receipt. Later on you will get a certificate from the NBA. That certificate that has to be submitted before the grant of patent. A copy of that certificate is suffice to be submitted with the patent office before the grant of your patent application. If you are not submitting that, then they will withhold your patent grant till you submit that certificate with the patent office. So when you're coming up with your soap, so not you would have done a lot of research to come up with the composition, right? A soap composition or a herbal care composition. So in that scenario, you have to clearly give some illustrations and examples like what are the various percentages you tried to achieve that invention, and you have to give the ranges. For example, ingredient A 30 to 40%, ingredient B 50 to 60%. So the ranges and the exact percentage or the specific percentage at which your invention is achieved. All that experiments which you have done along with the test results has to be included in the specification, because biotech related inventions, it is very difficult to get a patent granted unless and until you show the technical efficacy or synergistic effect of what your invention has achieved. All the details has to be submitted with the patent office. And any sequence listing is there, that sequence listing should be given in an electronic form, and there is separate fees that has to be paid for that along with the specification. And whatever I have told, I have given a simple example here, and so referring to the figures, you can just explain first introducing the elements. So here if you see, multi-adaptable water filter assembly comprises of a filter holder, the part number with at least one slit, the part number. So further, what are the various components? So you have to first list out the various components in your product, and then how it is interconnected and how on the whole this filter assembly is working. This is how you have to write. No word limitations for writing the detailed description also. Only thing is, if it goes beyond 30 pages, you have to pay the excess fee. And after the detailed description, you should start with the claims. So in my next slide, I will be showing the claims part. Before that, I'll just finish up with this abstract. So the abstract, you have to include the abstract also with the complete specification. This abstract should be in a separate page. It should not be in a continuous format. It should be in a separate page. And abstract is nothing but the concise summary of your invention. Whatever you have spoken or whatever you have written in a 30 pages, that should be written in 150 words. As for the title, it should be 15 words. Similarly, when you write an abstract, it should be a concise summary of your invention, and that should not go beyond 150 words, 150. You have to clearly explain the invention with that 150 words. And if you want to include some reference numerals for the components which you want to describe in the abstract, you can very well include that reference numerals also in that abstract. So when an invention gets published after 18-month publication in the Patent Office Journal, this abstract also will get published. So on reading so first I will read the title. If I feel that it is similar to my invention, then I will read through that abstract. So the abstract should be drafted in such a way that it constitutes an efficient instrument for the purpose of searching in the particular technical field, and it should be possible to assess where there is need to consult the specification. So once after I read the abstract, then I will come to a conclusion whether I have to read the other parts of the specification, that is the detailed description. So that on reading to the abstract itself, I should know whether it is very much related to my invention. So what is the technical problem you have taken in a hand, and what is the technical effect you have come up based on that problem should be clearly made in 150 words in that abstract. Okay. So now we'll quickly come into the claims section. So this starting from the title, you write the title, the field, the background, the objects of invention, brief description of drawing, summary of invention, summary part, brief description of drawing, detailed description. So all the subtopics will be in a continuous page. Abstract will be in a separate page. Similarly, the claims also should start in a fresh page. It should not be in a continuous specification. Okay, that should be clearly noted. So the claim is an important part of the specification. It's like a heart of your body. So whatever descriptions you give in a 30 or 40 pages specification, that is not going to give you a monopoly protection for your invention. Whatever features you put it in under the claim section, that will give the protection. So the patent rights exist only in the claims part and not in the other parts of the specification. So claims give the scope of the legal protection of your invention. So you should write it clearly, and you have to particularly point out what you regard as the invention. And only patentable subject matter can be claimed under the claims part. And of course, there should be unity of invention. As I said, if you are claiming for your product and the process, it should be interlinked to each other. It should be of the same subject matter. And of course, there is no restriction in writing the claims. Each claim, it should be of a separate, it should be of a single sentence, and it can be have some paragraphs also. And each claim should be serially numbered, 1, 2, 3. So it should be serially numbered. You can have n number of claims. And again, here, up till 10 claims, you need not pay any fee. If you have more than 10 claims, then you have to pay additional fee in excess of each of the 10 claims. Similarly, as I stated earlier, when you go beyond 30 pages, for each page, you have to pay excess fee. Similarly, when you go beyond 10 claims, for each claim, you have to pay the excess fee. So each claim is evaluated on its own merit, and therefore you should not think that if one claim is rejected, all the other claims also get rejected. No, that is not like that. So each of the claim will be evaluated on its own merit. And the purpose of writing the claim is, as I told, that patent right exists in claims. So the claims actually form the protective boundary. It is like a compound wall for your house. So it is a boundary that lets others know when they are infringing your rights. So you are putting a boundary. So that boundary is called the claims. Okay. Basically, there are, so when you see a patent specification, you will be just seeing the claims section. You may not be aware what is that claims all. So that claims, basically, if you see, there are two types of claim, the independent claim and dependent claim. Independent means, as the name implies, it is a standalone claim and it does not depend on any other claim. Normally, the first claim is called the primary claim or independent claim. And further to which you will have dependent claims. As the name implies dependent, it will depend on some other claim. It may depend on the first claim, or it may depend on any other dependent claim. So if it's so, then it is called as dependent claim. Okay, and it will be the, if you see that nomenclature, it will be like a product as claimed in claim 1 and apparatus of claim 1. So these are the various nomenclatures that you can see in the dependent claims. So whatever I have told is here the significance of claim. No monopoly can be obtained for any matter described in the complete specification unless you make it in the claim part. Okay, whichever is not claimed in the claims will be disclaimed, which means that the other parts of the specification will be open to public use. So you cannot write too broad claim or you cannot write too narrow claim. It should be written in such a way that the first claim clearly talks about your invention, the technical solution you have achieved based on the problem which you have taken in hand. Ma'am, the time is up. Shall I continue? It will take another 10 minutes. Can I continue with that, ma'am?
Yes. Yes, ma'am. Yes, ma'am. You can continue, ma'am.
Yeah, in another 10 minutes, I can complete it.
Yes, ma'am.
Okay, ma'am. The structure of claim. So as I said, that claims should start in a fresh page. And it should be with the preamble I or we claim, which means that based on the category of the applicant, if you are a natural person, it will be I claim. If it is an legal other persons like a college or institution, then you should have the preamble as we claim. And as I said, it should start in a fresh page and it should be of single sentence. And it can have subparagraphs and paragraphs, but when you start a claim, it should end with a full stop. It should be of a single sentence, and it should not have any vague words. It should be clear. The word should be very clearly mentioned, and whatever words you use, that should have a basis. When I refer to the specification, that terminology should be there. No new words or new terminology can be newly brought in the claims. Whatever words I'm using, that should be there in the detailed description or the other parts of the specification. So when you see, the claim will usually be of three parts: a preamble, a transition, and the body. A preamble is nothing but an introductory phase which identifies your invention. So on seeing to the preamble, you can see that whether your invention is to a product, it is to a device, or it is to an apparatus. And always keep the preamble consistent with the title of the invention. So this is how the example, a weighing apparatus for visually challenged. This is called as the preamble. On seeing to the preamble, I will know that, okay, you are claiming for a apparatus. And if it is a composition, then it is known that you are claiming for a composition. Okay, so this is how the preamble is written. Whatever it is your object, that from that object you have to frame the preamble. So if you are making a beverage from the herbal plant-based substance, then your preamble will be a method of making herbal plant-based beverages. Okay, so that is how, based on that object, you have to frame the preamble. The next will be the transition phase. That it is between the preamble and the body. Actually, there are two types of transitional phase: open-ended and closed-ended. Open means they are inclusive but not exclusive, whereas closed phrase means which limits the claim to nothing more than what you have recited as elements. If you use the word, you are using the closed transition. I have given some examples. If it is open-ended transition means you can use the transition like comprising, comprises, having. These are the transitions you can see. So a filter assembly comprising means these are the list of components, and apart from these components, there are some other list also. If we use this open-ended, whereas so comprising, I have given some example, a weighing apparatus comprising the components. Okay. Next one is closed-ended transition, which means that whatever I'm listing out as elements, that are the elements, and there are no other elements in my claim. Okay, which means then you can use this transition word consisting, consisting, composed of. These are called as closed-ended transition. A device consisting of A, B, and C, which means in my device, I have only these three components, and that's how you can explain. You cannot include any other component apart from A, B, C when you use this transition phase consisting. You can see maximum in biotech inventions, or where you claim for a composition or a formulation, there you can see this the transition phase consisting. Next is the transition phase. So you put the preamble, a product comprising, and you list out the elements. Okay, so after listing out the elements, you have to describe how it is structurally and functionally connected. So that listing of the elements and how it is structurally and functionally it is interconnected and the technical solution is achieved, everything will be covered under the part called as body. So the body, so after the transition phase, this body, so you recite the elements and then you explain how structurally and functionally these elements are interconnected and how you are achieving the technical effect. So you can have paragraphs, sub-paragraphs, but one point to be clearly noted is it should be of single sentence. I have given a simple example here. So a foot peeler will be the preamble. Comprising is the transition phase, and all that which is there in the purple color, a handle, a holder, a cutting element, all these are the called as body. So I am reciting the elements and then I'm telling how that peeler is made of or how the components are arranged in that foot peeler. So that is called as the body. So your claim will have three parts: preamble, transition, and body. Yeah, a patent claim cannot be merely of parts alone. If I say a pen a writing device comprises of a pen and eraser, is that claim is complete? No. If you make such a claim, what happens is you will infringe all the existing available pens in the world. So you cannot write a claim simply mentioning only the parts alone. A writing device comprising pen and eraser. You to tell how these elements means this pen and eraser, how these elements are interconnected and how it is technically advanced when the other prior arts are concerned. Then only your claim gets complete. Okay, so that explanation should be there. Otherwise, simply reciting your elements alone would likely be rejected. Okay, so you have to recite how it is structurally and functionally connected. So that recitation, that structural and functional features has to be explained by using a terminology called wherein. See, wherein. This phrase you can see in the claims. You can use this clause or phrase to further define the structure or further provide a function associated with the given structure. Okay. If you recollect that earlier example, here I have given a writing device is the preamble, consisting is the transition phase, and pen and eraser. So if you simply put pen and eraser, then as I told, it is a broader claim and you cannot have a protection simply claiming a pen and eraser. Okay, you should tell how this pen and eraser are structurally and functionally attached and how it is new and inventive when compared to the prior arts. So that will be explained using the terminology called wherein. So now you, after giving the elements, you have to tell wherein the eraser is detachably attached to the pen and wherein the pen eraser is provided with a cap. So whatever newness you have brought when compared to that prior art, that has to be explained by using the clause called wherein. So now only your claim gets complete, and this is how you have to write the claim for your patent, whether it is to a product or to a process. This is another example, a plant nutrient composition comprising so and so, and how it is interconnected should be given in the using the clause called wherein. Simply you cannot write a claim. Okay, so each and every phrase you use, you should have some punctuations to be used in that one. Okay, a preamble and a transition should be separated by a comma. After transition, it should be a colon, and after that the elements should be in the semicolon, and then the wherein clause should be with commas and it should end with a full stop. This is how the claim punctuation should be there when you write a complete claim. And when you introduce the element, you should use the indefinite article a or an. And then when you further refer that same elements in your claims, then you should use the definite article the or said. Okay. So when I show some example, you can clearly understand. Now, weighing apparatus. So when I'm just introducing weighing apparatus, so it should be with that article weighing apparatus, comma, comprising, colon, the elements, weighing element, weighing balance, electric circuit, power source. So all should be with semicolon, and then you have to give, this is not, please be noted that it is simply an illustration only. This claim is not a complete claim. To show the punctuation, I have given this one an antecedent basis. So weighing balance, an electric circuit, power supply source. So you have to introduce the element with a or an. So when I write the second claim, then already claim 1 I have introduced, right? So when I write the second claim, I have to use the weighing apparatus as claimed in claim 1. And then I'm using to explain further functionality, I'm using the clause wherein the weighing balance. So already weighing balance has been introduced in the first claim. So when I want to further explain what that weighing balance is, I'm using the article the weighing balance comprises a beam, etc. Whatever functionalities you want to explain, you can explain it with beam, weighing, weight measuring pan, metal strip. So this is how you have to write the claim. First claim, second claim, third claim. The weighing apparatus as claimed in claim 2, wherein the metal strip suspends at the middle of the beam. So if you see, I have depended on claim 2 and not on claim 1. Can you guess why? Because claim 2 only newly introduces metal strip and not there in metal claim, first claim. Did you find metal strip in claim 1? No, it has been newly introduced in claim 2. Okay, so because of that, I am depending on claim 2 and saying the metal strip freely suspends at middle of the beam. Wherever you introduce with article a or an. When we want to further explain that components, you use the article the or said. If you and one more point, if you simply out of ignorance, if you make the claim as claimed in claim 1, then the examiner will raise an objection that this claim cannot be evaluated because it is not properly depending on the proper claim. So it is indefinite and it is not clear and it is vague. No, then what you have to do is you have to clearly depend on which that particular claim, and you have to amend the claim and submit it with the patent office. So another example. So this is how you have to write. And another point, when you write the claim, that you have to introduce the reference numerals in the bracketed expressions when you write the claim. Since it is a mechanical or electrical invention, whatever invention may, you have a number of part numbers listed in the figure, right? So in order to avoid confusion, you have to, whatever part number you have mentioned in the drawings, that part number should be clearly put in the bracketed expressions when you draft the claims part. So for example, weighing balance 1, electric circuit 2. So that should be, so when the examiner or controller wants to look back to the specification with this reference numeral, they will look it and see how it is connected in the figure. So it's better to include the reference numerals in the bracket, either square bracket or curve bracket. It's up to you. You can use that one and you can make it while you write the claims. So an independent claim should cover all the essential elements and interconnection of elements and the technical features. A dependent claim will further explain the elements which is there in the first claim. Okay, so this is how you write the independent claim and dependent claim. And there is another claim called process claim. So when you want to claim a process of manufacturing a soap or a herbal hair care composition or a manufacturing of a ball, you can that claim will be called as a process claim. So a process, I have given a simple illustration of a process claim. When you write a process claim, you have to write the step-by-step method of manufacturing that end product. So that is first point. Then second point, when you write that process claim, always use the present continuous format, that mixing, then filtering, then adding. So whatever may be the steps, use it in the present continuous format and draft the claim. Say, for example, a process for preparing sugar-free nutraceutical enriched sweetened sesame bar consisting the steps of mixing all the ingredients to a mixture, adding water to the mixture and mixing uniformly, spreading the mass, baking them the thin sheets. So all this, whatever steps you are making, whichever is novel and inventive, that steps can be made it under a process claim. This is how a process claim will be returned. And so that's it, my session. I have quickly rushed up with the drafting of the patent specification. The most important is claims part. I hope whatever explanations I have given, that would be quite useful for you to at least to come aware of how a patent claim is written and in a patent specification. So that comes my end of my session. Thank you. And any questions you can very well put forth to me. I can clarify the questions or doubts which you have.
Thank you, ma'am. Thank you, ma'am. Any questions from the participant side? You can also post the question in the chat box.
Thank you, ma'am.
Okay, ma'am. Thank you, ma'am. So as of now, we don't have any questions from the audience, ma'am. So if any question is being there, we'll be posting you to ma'am.
Yes, ma'am, not an issue. So whichever questions comes to me, just send me. I will just reply to that questions or any queries there. Thank you, ma'am. Thank you for giving this opportunity. Hope this session could be quite useful for you in drafting a patent specification. So thank you, one and all. Thank you.
Thank you, ma'am. Thank you, ma'am.
Thank you.
Participants, participants, please join the next session using the link which has been posted in the WhatsApp group on your mail. We'll start the session immediately. Not